climate change litigation is on the rise globally to also respond to delay in implementation of mitigation policy in particular. But this event in particular will focus on a growing trend highlighted by some recent cases of what we deemed the personalisation of climate litigation. As you can see from the brief outline that's on your screen, we'll start from the scientific progress underpinning that evolution, and then focus on the question of an individual person's rights to a safe climate, before going to the obligations that not only corporations or countries, but individuals have to act on climate change. Welcome again, and I'm really delighted to be joined by a fantastic panel. I'll introduce them just before they're due to speak, but just to let you know, there will be at the end between 30 and 45 minutes of Q&A, question and answers with the panelists after their introductory presentations. You're very welcome to ask questions through the chat, and I'll select them when it's time for these questions. The event is recorded and also will be available on replay, so feel free to share it far and wide. I'll first turn to Michael Berger, who's our first panelist and the Executive Director of the Sabin Center for Climate Change Law at Columbia University. We're really delighted to have you, Michael. Would you like to give us a head start on the science that underpins this growing trend?
Of course. Thanks so much, Lola. Let me have one moment here to share my screen. And we can get going. So thanks so much, Lola, to you and to IDDRI and Sciences Po and the Sorbonne for pulling this together. It's a real pleasure to be here with Marta and Sarah to sort of share some of our thoughts about this interesting turn or thematic strain running through the trends in climate litigation. What I'm going to do today is I'm going to talk a bit about sort of the big picture of climate litigation and some of the trends that we're observing, and focus then on the role of attribution science. Because as we think about the personalization of climate law, about individual impacts and individual responsibility, drawing that connection between the global phenomenon of climate change and the highly localized impacts and individual responsibilities takes some scientific lifting. So I'll dive right in. As Lola mentioned, climate litigation really stems from a fundamental problem of collective action. As everybody on this webinar, I'm sure, is aware, we are not on course to meet the goals of the Paris Agreement. As the Carbon Action Tracker has outlined in its most recent update of its very helpful graphic, with real-world action based on existing current policies, we're on track for a global warming scenario of 2.7 degrees scenario in the average outcome. And in the most optimistic scenario, where there's full implementation of every announced target, including all net zero targets, all NDCs, we're still getting close to 2 degrees Celsius, so not in line with 1.5 degrees Celsius. And this can be attributed in part to a policy gap or a series of policy gaps. The Climate Action Tracker also keeps track of the sufficiency of the NDCs, global commitments, and as you can see on their helpful map, the world's leading emitters all fall somewhere between critically insufficient and insufficient, with very few countries worldwide with almost sufficient pledges and nobody with a 1.5 degree Paris compatible set of policies. In addition to this policy gap, there's a production gap, in particular global fossil fuel production. There's an extraordinary differential between the path that we're on in terms of the production of the fossil fuels that are the a predominant source of carbon dioxide and other greenhouse gas emissions that are causing global warming, and where we need to be in terms of ramping down fossil fuels and keeping those fossil fuels in the ground to be consistent with a 1.5 degree scenario. So given this insufficiency and the insufficiency caused by the policy gap and the production gap, it's not really a surprise that individuals, communities, community groups, subnational governments, NGOs, and others and national governments as well, and actors in the private sector are turning to the courts to seek redress. Over the last 5 years or 6 years, the Sabin Center has partnered with the United Nations Environment Program to set out a series of reports. We'll have our most recent update to the Global Climate Change Survey coming out in the next month or so. These reports are developed from the Sabin Center's climate litigation databases, which are available for public use at climatecasechart.com. And one of the things that happens in these reports, and what you'll see in the upcoming report, is that we've seen an approximate doubling, more than a doubling of the number of cases worldwide that have been filed since our first report was filed in 2017, and nearly a tripling in the number of jurisdictions in which we see climate litigation taking place. Now, when thinking about climate litigation, we always, at the Sabin Center at least, sort of divide between the United States and global cases, because the number of cases in the United States is quite simply an order of magnitude higher than the next leading single jurisdiction, which would be Australia. So we are seeing a definite increase in the number of cases, a definite increase in the number of jurisdictions, and a real trend in an increasing number of cases being brought in the global south and in international fora, such as the European Court of Human Rights, which Marta will talk about a little bit later. Generally, when we're looking at these at climate litigation, the vast majority of cases are brought under existing statutes or policies and causes of action that are available to plaintiffs or petitioners or applicants to bring cases to enforce or implement or challenge those statutes and policies. There are also a good number of cases that we see in regards to constitutional and human rights. And then the smallest sliver that we see there is in regards to common law and tort theories. In our most recent report, we'll be providing an update of the kind of trends that we see. And I'll stop on this very briefly because I think in Marta's presentation about rights cases and Sarah's about these corporate accountability cases, we'll be seeing some particular instances of these thematic trends. But in our upcoming UNEP report, we talk about 6 different trends in climate litigation. One is climate rights, in which we have both domestic cases, which are brought under domestic constitutions, or seeking to enforce or create a right, recognize the rights of nature. International climate cases, which may be brought in UN fora or in regional bodies. Domestic enforcement of the existing statutes and policies that are in place. A series of cases that are simply geared towards keeping fossil fuels in the ground, whether through environmental impact assessment cases, challenges to extraction and leasing, trying to keep carbon sinks from being torn down or dug up. And then we move to corporate liability and responsibility cases, which take a number of different forms, cases around disclosure and greenwashing, and then cases around adaptation, which, while they are overall a smaller number of cases, still form a significant part of the body of cases that we see. So again, as I mentioned at the outset, climate science is central really to all of these cases, and is an important part in drawing any sort of proof plan and for a plaintiff, and is important for even getting into court in many instances. So I'm going to talk about a few different types of cases here to give a sense of what the science is and how the science factors into these cases in important ways. One category of cases seeks to involves suing governments for regulatory inaction and for their contributions to climate change. And in these typical cases, such as the Juliana case that's pictured here, which I'll talk about in a moment, citizens or public interest groups, or sometimes subnational governments, are seeking court orders to accelerate greenhouse gas emissions reductions and end policies such as fossil fuel subsidies. In a different, in the corporate accountability space, we see plaintiffs seeking to impose liability for corporate contributions to climate change. And some of these cases might involve plaintiffs seeking monetary damages to help cover adaptation costs, as well as changes in corporate conduct. And some of these cases, in particular the cases brought in the United States, are pursuing a public deception theory where the liability of the private sector actors is not premised on a strict liability theory about the downstream emissions associated with their products, but rather on disinformation, deceptive marketing, and a failure to warn. Another sort of category of cases that we see here are corporate greenwashing suits, which might be brought on behalf of consumers or governments under consumer protection statutes involving the marketing and speech around commercial behavior involving fossil fuels. The adaptation cases, take a number of different forms, and some of these are focused on corporate behavior, such as the failure to disclose cases, where these cases can involve challenging government action or corporate action about failures to analyze and disclose climate change related considerations. This might take place in relationship to planning documents, EIA, financial disclosures, or other contexts. Failure to adapt cases also involve challenging government or corporate failures to prepare for the impacts for climate change on infrastructure, on communities, or on natural resources. And then there are actual defenses of adaptation cases where entities that have taken adaptive action have to defend the actions that they've taken against legal challenges. So detection and attribution research, again, is central to these cases. In our paper from a few years ago, The Law and Science of Climate Change Attribution, my co-authors and I identified 4 key areas of detection and attribution research that factor in different ways into these cases. One is global climate change attribution, or the group of working group 1 of the IPCC, which asks, how are human activities affecting the global climate system? Extreme event attribution, which asks, how are changes in the global system affecting the frequency, magnitude, and other characteristics of extreme weather events? Impact attribution, which reflects the work of working group 2 of the IPCC, which asks, how are changes in the global climate system affecting the interconnected natural and human systems? And then finally, source attribution, which isn't really sort of its own area of detection and attribution research, but has arisen in specific response to the demand to account for responsibility for climate change, which asks, to what extent have different sectors, different activities, different entities, which can include government entities as well as corporate actors, contributed to climate change. So the way that this research, that the science factors in, primarily can fall into these 2 areas, causation and foreseeability. With regards to causation, the science is essential to establishing a causal link between a particular defendant's conduct and their contribution to climate change, and ultimately the injuries that are experienced either by a public entity or by individual plaintiffs. So you see here sort of the flow that moves from a defendant's conduct, the contribution to global climate change, that connection to the physical impacts, and then that contribution to the actual harm experienced by, as we're discussing today, human individuals. The other area is the foreseeability of these impacts, demonstrating that the climate-related impacts are foreseeable and therefore should be considered in decision-making and planning processes, either before the fact or afterwards. What does this look like in practice? I'll take a couple of minutes to talk about two examples. In Juliana versus the United States, the youth litigation here in which youth plaintiffs filed a lawsuit against the federal government in the United States, alleging violation of their constitutional rights and of the government's public trust obligations. Plaintiffs supported their case with declarations by the 21 plaintiffs and reports from 18 experts, as well as hundreds of government records, to establish a scientific basis for their ability to be in court and for the violation of their rights. This included some of the leading experts globally and in the United States. And you can see that these expert reports addressed a range of the types of detection and attribution science that I mentioned before: climate attribution, impact attribution, source attribution, and extreme event attribution. All were submitted in different forms by these and other experts. The one expert report submitted by Dr. Kevin Trenberth provides a nice example of how this does break down to the individual level. There is a connection, the need to draw a connection between climate change and extreme events, such as hurricanes, floods, droughts, and wildfires. Dr. Trenberth also discussed specific examples of extreme events that have been attributed to anthropogenic climate change. The report, as well as the declarations provided by the plaintiffs, also talk about the effect of the extreme event on the youth plaintiffs and provide specific examples of the particularized, individualized injuries they've experienced, which include, in that case, property damage and displacement due to storms and flooding, the experience of increased asthma attacks as a result of wildfires and this related smoke, and displacement due to water scarcity. In another instance, in the corporate context, we have the famous lawsuit of the Liua versus RWE, in which a Peruvian farmer has sued the German utility RWE for its contribution to climate change, seeking compensation based on the costs of protecting his town and his farm from flood risk associated with glacial retreat. In particular, the plaintiff there is seeking a proportional share of that cost associated with RWE's proportional contribution to global greenhouse gas emissions as measured on one metric or one methodology. So we have the source attribution, which attributes RWE to RWE 0.47% of global greenhouse gas emissions over the course of history. And then we also have a study where climate scientists conducted a targeted attribution study and found that anthropogenic climate change was responsible for essentially all of the observed glacial retreat. So we have there a connection between the source in climate change, and the impact and its particular harm or injury to the individual plaintiff involved. Now, I want to talk very briefly about the adaptation cases, because even though these are the ones here don't necessarily involve individuals in the same way, they're nonetheless, I think, emblematic. So here we're talking about lawsuits challenging the failures to prepare for the impacts of climate change on infrastructure. And attribution is primarily used in these cases to demonstrate that the climate change impacts are foreseeable, and thus the defendant has an obligation to account for those impacts in its planning. So in these cases, here are some of the cases that we've identified as sort of significant and again, emblematic in this area. Their lawsuit of Conservation Law Foundation versus Massachusetts, DEP, which challenges the siting of a landfill on a coastal area that's vulnerable to sea level rise and other climate impacts. So we're talking about, in that case, understanding the specific threat that sea level rise poses to a particular location and why that's significant for a particular infrastructure or facility siting decision. A case in California where landowners have challenged a coastal plan which would prohibit long-term shoreline protective devices such as seawalls, claiming that this would limit their ability to protect their own properties from sea level rise. So again, that particular relationship between a particular location and the global phenomenon of sea level rise. another lawsuit brought by the environmental organization Conservation Law Foundation, this one against Shell, which is not a fossil fuel case, but is rather about the coastal infrastructure and alleges violations of the Clean Water Act. In particular, it's the requirement that the coastal facility have a stormwater pollution prevention plan sufficient to protect against likely spills and discharges related to extreme precipitation events and sea level rise in coastal infrastructure. And then finally, Cole versus Collier, in which a Texas federal court recognized the government's obligation to protect inmates in a prison from extreme heat events, which will be exacerbated by climate change. So in that case, we're looking at the global warming, extreme heat events, and the particularized impacts on individual inmates in a particular location and the obligation to protect against that impact. So here's just a sort of smattering of some of the important studies that look at government obligations and assigning responsibility or attributing responsibility for emissions to governments, the economic impacts that can be caused by climate change, and then the corporate obligations. A number of different studies identified here that either attribute emissions to corporate actors or attribute activities to corporate actors based on their long knowledge about climate change, as well as some studies that actually make the connection between emissions contributions and a particular proportional contribution to particular impacts such as sea level rise. I'll sort of close by just noting that we at the Sabin Center have, along with our climate change litigation database, a number of other resources, including the climate attribution database at climateattribution.org, which seeks to bring together scientific resources, which we think are important and meaningful for climate litigation and policy. And with that, I will turn it back over to Lola, and thanks so much. Looking forward to the Q&A.
Thank you so much, Michael. That was fascinating and really a wide-ranging presentation. Already a few requests to share the slides, and considering the amount of references you have, I think we absolutely should, if you don't mind. Just a quick question of clarification. You pointed a few cases brought forward by individuals, including youth in Juliana case, or foundations, homeowner associations. Can you say something about how successful they were and how the judges tend to rule, on average, if possible?
Well, I don't think that we have an average outcome yet, and I know that we'll hear more from Marta about some of the ongoing cases at the European Court, and from Sarah about some of the newer forms of cases around corporate obligations and boards and directors. In the Juliana case, ultimately, it went to the Ninth Circuit Court of Appeals in the federal court system in the United States, so the intermediate court of appeals before the Supreme Court in the United States. After the federal district court, the trial judge had denied motions for summary judgment and found that the issue should move towards trial. And the Ninth Circuit Court of Appeals agreed that the plaintiffs had sufficiently demonstrated the possibility of proving individual harm and causation. So those two key pieces of connecting the United States government's contributions to climate change and then connecting the global climate change impacts to individual injuries, that at the least there were material issues of fact requiring a trial. But the court ultimately dismissed that case based on redressability. So the court found that the particular relief that the plaintiffs in that case were seeking, which was a court-ordered plan for national drawdown, was beyond the court's authority to grant. So it was based on sort of separation of powers principles and not so much on the science in any meaningful way. The Conservation Law Foundation cases that I mentioned are still all very much in progress, or most of them are still in progress. And again, in those cases, the I guess that I would say that there is a trend towards courts finding that there is at least a triable issue of fact, that there are material issues of fact around causation that require more record development and should not be dismissed out of hand. And in some of the cases around corporate accountability and fossil fuel company accountability, we're still in very early stages, but those cases also have a range of outcomes where it seems possible that the individual company responsibility will be put to trial. In the Peruvian farmer case, that is where things are now. The German court there initially dismissed the case. The appellate court then held that it was not legally, that it shouldn't be dismissed as a matter of law. And the judge is now, that case is now in an evidentiary phase and actually involved a trip by the judge and the parties to the village to take a look at the glacier and get a sense of what it looks like on the ground.
Thanks a lot. A lot of complexities regarding the US legal system, but as you've shown, 70% of litigation is actually taking place there. So important that we get up to speed.
Well,
I'll now turn.
I should note, sorry, Lola, just very quickly, the Peruvian farmer case is in German court, not in the United States.
Yeah, sure. Thanks. I'll now turn to our second panelist, Marta Torre-Schaub, who's a research director at the CNRS in environmental law, teaching at both Sorbonne University and Sciences Po, and who leads the interdisciplinary network Climalex on law and climate change. Marta, the floor is yours on the question of rights.
Thank you. Hello, everybody. I will try to share my screen. Okay, so there it is. Okay, but okay. So I will focus on rights in the context of some European cases before the European Court of Human Rights. And the question I'm asking is if climate litigation can really get personal and if courts can really accept that, which is not that easy, as we will see. So some elements first of introduction, as we have seen with Michael, the climate litigation emergency is a really toolbox for fighting against climate change and fossil fuel and all that activities, and it's part of today what we call the climate change governance, which develops not only with policies and the implementation of policies, but also before courts. This is recalled by the last IPCC report, and what its aim and what we are really trying to pursue is to have more ambition, enough ambition and more strength in climate change policies. But there are many aspects concerning people, individuals, or specific groups that sometimes or very often are left behind or are not enough taken in consideration. So this is why I will focus especially on rights. So if we consider that climate change litigation can be a bridge before people and climate change law and rights, we will understand more easily this new trend of climate change litigation. And the key argument in these new cases is really the failure for states to protect people against negative consequences of climate change. So some key elements first, maybe, to understand the context. One is recalling that in the European context, there has been another case, but before the Court of Justice of the European Union, the People's Climate Change case, or Carvalho case, that was presented before the European Union Court in 2017, which was dismissed. And for different reasons, but that are really connected to the reason why now there are cases before the Human Rights European Court. And they are explained in the decision of the European Union Court of Justice decision on March 25, 2021, dismissing the case. And it was mainly, the court say mainly that the applicants didn't claim they didn't really have a standing because they couldn't really establish the existence of an individual concern, and that the court then couldn't accept that, and that the argument seeking to have criteria for individual concern could not succeed for the court. And second element interesting is that the European Convention of Human Rights, which is what the European Court of Human Rights apply, has not a precise article on environmental matters. So the European Court, when decides under the European Convention, has to build a specific jurisprudence, a specific doctrine, in order to protect both human rights and the right to a healthy environment. They have to invent new ways in order to use other articles of the European Convention of Human Rights, which are mostly Article 2, which protects the right to life, Article 8, which protects the right to a private and family life, and mostly the right to have a peaceful home, and the Article 6, which is the right to have information, participation, and access to justice. So the court has always to deal with this absence of a specific right to a healthy environment, and to interpret the other articles, which is not easy, and which in the climate change context will be probably even more difficult. There has been some cases in concerning environmental matters before the European Court of Human Rights, but this is a difficult path to accept this right, and more when it comes to groups or collective people, and I will explain that. So why these cases will be important? First, because they will be the first cases before these courts. Second, because the decisions will probably have an impact in other courts, and maybe before the European Union Court of Justice, as we have seen, is not. This court don't want to deal with that for the moment. So maybe with the European Union with the European Court of Human Rights, this will have an impact. Also because that will enhance, of course, states' obligations on climate change, and because that could also inspire the International Court of Justice. We will come to that later. And also because this will be a way to accept climate vulnerability as an element of breaching the right to life and the right to a private life and to a private home, and also because that will recognize higher standards of the duty of diligence concerning the different states. Presently, there are 10 cases before the European Court of Human Rights. 3 of them are pending, which I will present briefly. The first one is the Klima Seniorinnen and others against Switzerland, which the hearing took place last March, on the 29th March. The Carême case against France, which also the hearing took place also on the same day as the Seniorinnen in the afternoon, and the Duarte, Agostino and Young Portugueses against Portugal and 32 other states, which the hearing took place in at the end of September. So first, the Klima Seniorinnen. The characteristic of this case, which is really fascinating, is that the Klima Seniorinnen are a group of senior women, old women with a certain age in Switzerland, and this application is brought by this group and also by 3 of them individually. What they are claiming is that there is a failure from the state to do the necessary to reduce the greenhouse gases, and also a failure to protect them as a group, but also as individuals, as victims from all the adversary effects and negative effects from climate change, especially all the consequences because of the excessive temperatures, the illness that are caused because of that, and then the breach of human rights, especially Article 2 and Article 8 of the European Convention, so the right to life and to happy family, private life, and a peaceful home. And they are asking the government to recalculate the trajectory of the reduction of greenhouse gases. Mostly they are asking the government, the Switzerland government, to apply the due diligence according to the Paris Agreement 2 degrees target, and if possible 1.5 target. They are also asking for a more fair share between countries in these reduction efforts, but the government, of course, has his own arguments, which in the Carême case are more or less the same. So they are mostly first the argument of the drop in the ocean, which means that why one specific state should do more or more efforts if the efforts have to be done by all states at the same time, and it will not be worth if just one state will do more efforts. So basically, the Switzerland government and the French government, in the hearing and in the responses to the applicants' claimings, they were using both these arguments. Another argument that is also common to these two climate change cases is that the states ask the court to recognize their freedom to have the margin of application of their own law and their own measures, which is in the tradition of the jurisprudence of the European Court of Human Rights. So they very well know that in asking that, the court will be sensitive to this specific question. And the main argument of both governments, the Switzerland and the French, is to say that it's an action popularis and not an individual claim, and thus this is out of the scope of the court and out of the scope of the convention, which means that they are trying to convince the court that is not an individual petition or a specific group or collective petition, but an action popularis, which means a too general petition and a too general question. So as we can see, is really completely the contrary as the arguments of the European Union Court of Justice, which means that either one court with his own criteria and the other court, if they apply these criteria that the states are putting in front of them, none of the cases will be accepted and they risk to be dismissed, but wait and see. So the other case, very briefly, is the Carême case against France. Mr. Carême, Damien Carême, is the former mayor of the Grandson town, and he applied to the court for violation of his human rights covered by Articles 2 and 8 of the Convention as the Switzerland Seniorinnen. And he also exhausted all avenues for appeal before at the domestic level, as the Seniorinnen in Switzerland did. And he is also claiming the failure of the French state to take all necessary measures to reduce emissions, and the failure to take all necessary measures to protect his home and life. And the state is answering to that in a similar way as the Switzerland did, saying that all measures have been taken, that the Conseil d'État already ruled on that issue, and just for the record, yesterday the Conseil d'État ruled for the third time in the Grand Saint case, but is only concerning the Grand Saint town and not the individual petition of Mr. Carême. So at the end of the day, Mr. Carême has no remedy at all for himself. So it's totally fair that he goes before the European Court of Human Rights, but nevertheless, the state is trying to put forward all those arguments and in his favor. The state said too that there is a new climate act in France that has been published since the first apply of Mr. Carême, so all measures have been taken, and they are saying also that there is no personal standing for Monsieur Carême because he's not living anymore in Grand Sainte town for several years now, and because he is living in Brussels. And also, of course, they are responding with the Actio Popularis, saying that even though Monsieur Carême presents his application as an individual application, this is a disguised Actio Popularis, because in fact he is asking to the French government for 2 general measures and not individual measures. So it's an Actio Popularis and not an individual complaint. So this should be dismissed. The Duarte y Agostino, I just can present it very briefly, but as the hearing will take place late September, I don't think I can really bring many arguments at this point, but just there are 3 key arguments that the young Portuguese that present themselves as the future generations, and that they are being discriminated because there is no equity between present and future generations, and then that there is a breach and a violation of their rights to life, to non-discrimination, and to family and private life, because they are experimenting anxiety, frightened, they are having loss of possibilities for property, for health, to go to school, education in general, illness, insomnia, etc. So the 3 key arguments is first science, so that makes the link with Michael's presentation before, and they rely on the evidence of the last report of the IPCC. They also claim that there is a failure of all 33 states. They are asking for before the court, and they are accusing of failure. They say that all those 33 states are not staying at 1.5 point, and the legal point, of course, is the breaching of rights because all of the dramatic effects. So we will see what the court will say. So what are states doing or not doing until now? It's certain that they are failing to regulate properly limit emissions, that it's certain that they are breaching some human rights and some severe violations of human rights on permitting emissions, on permitting activities, on contributing to these activities, on investing on these activities, on financing those fossil activities. And another interesting thing that all the applicants say too is that the states are not putting in place a proper European authority to forbid activities on the basis on the Paris Agreement. So those are the main arguments. What are the limits of the court? So first, they will have to accept that there is not an Actio Popularis and that the claims are individual or at least from specific collective groups. This is particularly tricky and complex because there is a tension between the first aim of the court, which is to protect individuals or very precise groups, and the fact that climate change challenge, they can affect all and they can create injury to all. So we will see how the court deals with this primary tension. Also, another issue for the court will be to rule about the imminence and the seriousness of the climate change threat, so the time. Another will be the degree of the danger and the risk. And last but not least, it will be the causality link, of course, between the dangers and the emissions. And the court will have to fight against the drop in the ocean argument that was claimed by the states, saying that it's not worth to act one state by one, but the action should be collective. So why doing something? So the court will have to do an effort to pass over all those difficulties, but it's sure that all those climate cases are growing. Sooner or later, the European Court of Human Rights will have to move on and to be open and more flexible in the interpretation of Articles 2 and 8, and also to reconsider this argument of the actio popularis that the states are claiming. So to close my presentation, I will just say that some elements maybe can help or could help the court in her decisions. First is the recent recognition by the United Nations General Assembly of a human right to a healthy and sustainable environment. Also, we will see what happens with the latest demand to an advisory opinion to the International Court of Justice by the United Nations General Assembly in the name of Vanuatu and 193 other states, asking the court about the specific obligations of states under international law concerning climate change and future generations. And also there is another advisory opinion going on that has been asked by Chile to the Inter-American Court of Justice concerning also the precise obligation and the scope and the nature of states' obligations, due diligence, and future generations concerning climate change. So it will be very important that all courts, both in the decisions and in the advisory opinions, come to substantial decisions and will convene on the same direction, to be in the same page, interpreting international law, European law, the standards of diligence, the responsibility and the principle of equity between generations, and of course the violation or not of specific human rights. It will be important too that all those courts will rely on the Paris Agreement within the interpretation about the stabilization of climate system under 2 degrees. Also, it will be interesting that the courts will use and interpret the Paris Agreement in the best efforts and the quality standard of more appropriate measures. So to apply and to interpret the Paris Agreement and what the Paris Agreement can do for those decisions. But as it's very difficult to come to a global consensus of all states about those obligations, at least let's hope that the courts will show some minimum standards and some pathways for the interpretation of the state's obligations and rights. So thank you very much for your attention.
Thanks a lot, Marta, for this great presentation. I would now like to turn to our final panelist. Sarah Barker is Global Head of Climate Risk Governance at the international law firm Minter Ellison and based in Melbourne. So thanks very much for joining us despite the time difference. I'll let you get on with the third presentation regarding obligations. Thanks very much.
There we go. You should be able to hear me now. Correct. Excellent. Sorry, I'm on my phone as well as my laptop. So hello, everyone. As Lola said, I'm a partner at Minter Ellison, which if you haven't heard of Minter Ellison, we're the largest commercial law firm in the Asia Pacific. And I've got a very keen interest in the topic of directors' duties in relation to climate change. So here we're looking at the real pointy end of obligation for the leaders of the business community in relation to the actions or inactions of their business in relation to climate change, a failure to mitigate or a failure to adapt. And what I'm going to do with you today is first give you a very quick 101 about directors' duties from a first principles point of view, and then talk about the leading claim in the area, which is a recent case that Client Earth has filed in the English High Court against the directors of Shell Corporation personally. So let's look at directors' duties, often referred to as fiduciary duties, which is my personal favourite F word. So fiduciary duties. Directors are a fiduciary of their corporation. And as a fiduciary, there are certain obligations that you have to prioritise the interests of the corporation as your principal for your fiduciary obligation. So there's some fundamental obligations that any fiduciary has to their principal. And the first is to act in their best interest, to act with trust and loyalty, because the principal needs to trust that the fiduciary is going to prioritise their interests and not act in their own personal interests. But then there's a second part of the fiduciary equation, which is that fiduciaries have to meet a minimum standard of competence. There's certainly no good in a principal being confident that you're going to act in their best interests if you're just going to do a crap job of it. So there's also minimum standards of competence to which fiduciaries, and in this case, directors, are held. And so across every function that directors exercise for their corporation in relation to corporate strategy, in relation to overseeing material risks and the way in which management manages those risks, and in relation to reporting and disclosure, directors have to have regard to these fundamental fiduciary obligations that they have to the company. Now, these basic fiduciary obligations are reflected in corporate governance regimes all across the world, whether they're under the common law or whether they're under the civil law. And they're reflected in kind of three basic directors' duties that we have in all corporate governance regimes. The first set are obligations for directors to act in the best interest of their companies, to act in good faith, to avoid conflicts, to act for proper purposes or to promote the success of the company. And those are the codifications of the fiduciary obligations that relate to trust and loyalty. Then to codify the obligations in relation to competence, we have directors' duties around due care and diligence, or reasonable care, skill and diligence that are codified in corporate governance laws across the world. And usually these laws hold directors to a standard of what a reasonable director would have done in the circumstances. And then finally, we have the third set of directors' obligations in relation to disclosure and reporting, and to avoid misleading disclosure, or in some jurisdictions known as securities fraud. There's a bit of a blur in some countries as well, in particular countries like the US and Australia, where we have what's called stepping stone liability. And this basically means that a director can be held liable for a breach of their duties if they fail to ensure that the company itself has adequate systems in place to comply with the law. So we also need to be aware that a director can be found in breach of their duties to the company if, in fact, the company itself operates in breach of the law. So that's a bit of a whirlwind overview of the law of directors' duties from a first principles perspective across the globe. How do we think about that in a climate change context? How do these company directors' duties apply in a climate context? Well, this has certainly changed over the years, and certainly in the more than a decade that I've been looking at directors' duties in the exclusive through the exclusive lens of climate change and sustainability. It used to be that when we were looking at, well, are directors able to consider climate change in a way that's consistent with their obligations to prioritise the best interests of the corporation? It used to be that the orthodox view was, well, no, because climate change is this lefty, hippie, greeny, socialist thing that's non-financial, that's all about ethics. And so it's inversely related to the main job of a company to maximise financial wealth. So up until about 10 years ago, the orthodox view was very much that directors were simply not allowed to think about climate-related issues in prioritising. I've lost an ear. Prioritising the best financial interests of the company. Now, as we know, climate change is clearly a material financial risk and opportunity across the economy. And so therefore, not only are directors allowed to think about climate change, they're duty bound. They have a positive obligation to consider how material climate related risks and opportunities may impact on the generation of financial wealth for their company. In relation to that second duty around competence or due care and diligence, it used to be the case that at its highest, we thought about climate change as potentially a compliance issue. Is a company complying with laws under Environment and Planning Act, for example, or at its very highest, it was almost a PR issue, kind of a social license to operate kind of issue. But again, now, because we know that climate change is a material financial risk and opportunity, directors have a positive obligation. They are duty bound by their duty of due care and diligence to consider this foreseeable financial risk and opportunity, to consider whether or not it's material for their company. And then, in proportion to the magnitude of that risk, devote significant thought to its implications for corporate strategy, for risk oversight, and for disclosure, corporate valuation, etc. Finally, when it comes to that duty of disclosure, it used to be, again, because climate change was considered non-financial, it was considered immaterial to financial best interests, no mandatory disclosure standards, and to the extent there were any voluntary reporting standards, they related to narrative disclosures for companies in their directors' reports or MD&As or separate sustainability reports, which again were often PR documents written by marketing parts of the business. Now, of course, we know that these issues are materially financial. We know that materiality in a disclosure context with annual reports is tested not by reference to this kind of plus or minus 5% of revenue rule of thumb that companies often apply, but it's actually tested by reference to whether investors consider that it's decision useful information when they're making investment decisions. And on that basis, you cannot deny that climate change is material information for an investor and therefore material for a company to disclose in its annual reports. And of course, we now have this proliferation of mandatory disclosure regimes, like, for example, the SFDR, the CSRD over there in Europe. We have mandatory TCFD disclosure in the UK, Singapore, other jurisdictions. And so increasingly, directors are duty bound to consider these issues when they disclose financial information and other information to markets. So that's the theory. Climate change is a material risk, and therefore it's undeniable that directors are duty-bound to take it into account. But when I first started discussing this issue, as I say, more than a decade ago, the response from directors was, that's all very well and good, but show me the case. Until there's a case, it's all theory, and I'm not interested. Well, be careful what you wish for, because now we have a case. So we have this claim, as I say, which was filed by Client Earth as a shareholder derivative action in the High Court in February of this year. Now, the reason it's a shareholder derivative action, and what the hell does that mean for those of you who aren't corporate lawyers, fiduciary duties of directors are actually owed to the company. So if there's an allegation that those duties have been breached, it's only the company that can sue. And so what happens is that shareholders have to stand in the shoes of the company derivatively and bring a claim on the company's behalf. So Client Earth has gathered a group of institutional investors that hold more than 12 million shares in Shell to bring this derivative action against the directors. And the claims are that the directors of Shell personally have acted in breach of their duties to the company as set out under the Companies Act in the UK. And they're alleging a breach of the two primary duties that directors owe to UK companies. The first is to act in good faith and promote the success of the company, having regard to certain mandatory factors under the Companies Act in the UK, including things like the long-term success of the company, impacts on workers and the environment. And secondly, they're arguing that the directors have breached their duty of competence of reasonable care, skill and diligence under Section 174 of the Act. So why are they alleging that the Shell directors have failed to reach the standard imposed by their duties? And it's basically because of the acute materiality of climate-related financial risk to Shell's business. It is an oil and gas business. It is a fossil fuels business. And as we know, fossil fuels and the combustion of those fuels are the primary contributor to climate change. And so this claim really goes to the fundamentals of corporate governance. First of all, in relation to the breach, the alleged breach that the directors have failed to promote the success of the company. Client Earth is basically arguing, because you have failed to ensure that the company has a strategy that is aligned with Paris Agreement emission reduction targets, you are failing to promote the financial success of the company. Because the Paris Agreement is the mother of all market signals. It says to markets globally, this is where 195 countries are directing their policy in order to keep global warming within the scientifically safe limits. So if you are ignoring that mother of all market signals and failing to align your corporate strategy with the Paris Agreement, you necessarily cannot be acting in the best financial interests of your company and are failing to promote its success. So that's the first argument. The second argument in relation to the failure to exercise reasonable care, skill and diligence is essentially a failure of oversight. What they're alleging here is in relation to the emission reduction targets and strategies that Shell does have in place. Client Earth is alleging, well, they're actually insufficient to reach the targets that you do have in place. So they're alleging that the board has failed to adequately oversee and monitor management with due care and diligence by failing to ensure that management does put in place strategic plans that would even enable it to reach the targets that it has set. So the remedies that are being sought here as declaratory relief in the first instance, and secondly, orders that the board put a strategy in place that is aligned with Paris Agreement targets. Now, I'm conscious of time. I'm just going to quickly run you through, well, why are Shell's plans, decarbonisation plans, considered to be so inadequate? Because this might give us some clues as to, well, who might be sued next? First of all, as we've discussed, their targets and transition strategy is not Paris aligned. They have a net zero by 2050 target. It's only in relation to scope 1 and 2, and the ambition is very heavily caveated. In fact, it's essentially, and I'm paraphrasing, we will reach net zero if the rest of the global economy decarbonises. Because if no one's buying oil and gas, yes, well, we'll transition. Secondly, to the extent it has short and medium-term decarbonisation reduction targets, its absolute emission reduction targets are in relation to 2050 only. Its shorter-term 2030 targets are intensity-based, and they're insufficient. They're only in relation to scope 1 and 2, whereas for an oil and gas exploration and production company, 90% of its footprint is scope 3, which is where we burn petrol in our cars or burn gas in our houses, for example. The fourth reason is that Shell's transition plan relies on gas heavily as a lower emission source of energy, and its alleged unrealistic levels of carbon capture and storage and nature-based solutions, rather than switching its business away from fossil fuels to renewable sources of energy. The fifth reason is that Shell's transition strategy is really a wait-and-see approach. As I say, if markets start to shift, then it will shift. And then finally, it's alleged that Shell's CapEx is inconsistent with achieving the targets that it's set, and it hasn't adequately integrated the achievement of those targets into its operating plans and budgets. So when you look at all those reasons as to why Shell's emission reduction targets are considered insufficient, and why the operational plans of management in directing towards the achievement of those targets are insufficient, a lot of those rationales you can apply across companies, across the economy. This is not just oil and gas. Oil and gas, yes, it's the canary in the coal mine, or in this case, the canary in the oil and gas field. But I would ask, for which sectors is climate change not a material, physical, or economic transition risk? I have clients across diversified mining, the banking sector, retail, agribusiness, infrastructure, transport, and for every single one of these clients, the boards are extremely concerned about what do we need to do in order now to discharge our duties in relation to climate change, because they understand it's a financial risk. The final thing that I will add is that this is just the tip of the iceberg, to mix my metaphors, because what we're now seeing is the rise of strategic litigants. And whereas previously we almost exclusively saw breach of fiduciary claims in an example where there'd been a stock drop, a large fall in share price that shareholders were seeking to recover, or in the case of bankruptcy, again, where shareholders were trying to look to a remaining deep pocket that they could recover funds from. We've now seen the rise of strategic litigants like clientele, like equity generation lawyers here in Australia, for example. They don't need to wait for a stock drop to seek declaratory relief, to seek injunctive relief, because you don't need to show loss or damage. So my tip is that we're going to see a lot more directors' duties cases in the very near future. So I'll stop sharing my screen now. Always more than happy to take questions, and I'll pass back to you, Lola, to facilitate that.
Thank you so much, Sarah. This was really fascinating. I almost feel like you've turned us all into corporate lawyers, which is a tall ask. Unfortunately, I think because the presentation was so rich, I'm not sure that we have any time to take any direct question. Quite a few people have asked questions in writing, including, will we get the slides? And provided all presenters agree, yes, we'll share them to the registered participants. And also some that Michael has kindly answered in writing. So I'd direct you to those if you want to take a look. I'll maybe just give a very one sentence word of conclusion, if you want, on this particular trend before we have to close, unfortunately. I think we don't have time to get into anything more specific than that, regrettably. I don't know if Michael or Marta, you want to have a final word of conclusion, also maybe responding to the other ones.
Yeah, I guess I would just say that I think, you know, climate change is often conceptualized or understood in its global frame, and as a you know, still too often understood as something that's far off in time, mid-century, end of the century sorts of impacts, and something that happens to other people far away. And that's obviously not the lived experience, and it's obviously not what the science says. And what we're seeing in the cases that I discussed and that Marta discussed and that Sarah discussed is that the individual component of climate change is very real, very much lived, and it very much does sound in the law, both in terms of the rights that individuals are seeking to fortify and have recognized in court, and the obligations that individuals in particular circumstances owe to others to take account of and take action on these climate risks. So climate change is global, but it's not only local, it's also individual.
Thank you so much, Michael. I feel like this is actually near perfect conclusion to the time of themes that we try to weave together through this look at cooperation, human rights, and at progress in attribution science. So I'd rather we shut down the event now and we'll close it with your final words. Let me once again thank a really fantastic panel this morning for your fantastic presentations. Very honored to have been a co-organizer, and wish everyone a good rest of the day or evening and night if you're in Australia. Thank you, everyone, and thanks for joining.